Hello, good morning, and welcome to the number 5 Planning Enforcement Webinar, Planning Enforcement Revisited. We come together at the end of party conference season, those short few days where parties set out their agendas and where politicians are inexplicably unable to imitate being human beings doing ordinary things like eating fish and chips. I'm sure we've all seen Boris Johnson's bizarre TikTok. What about planning? Well, having achieved their key priority of rebadging the Ministry of Housing, Communities and Local Government to the Department for Levelling Up Housing and Communities, I'm not quite sure where local government went, but presumably they had to rename it from the ministry to stop Michael Gove from going there and dancing incessantly. But on planning reform, we know that the government still wants to build 300,000 homes, but not on greenfields, and not jammed into the southeast, but where they make sense. And presumably where they make sense is well away from anywhere where the government might lose votes. What about white paper reforms? Well, they've been paused because there isn't enough inertia in the planning system already. There is, however, no inertia in case law pertaining to planning enforcement, which brings me to our 3 speakers for today. We'll hear from Oliver Lawrence on the still changing world of confiscation in planning enforcement. Howard Leithhead is going to take us through a case law update and bring us bang up to date. And before Oliver and Howard, we'll hear from Sinead Davies, who's going to tell us what's been going on in the world of injunctions. Now, while Sinead's just getting herself ready, I'll just mention that we'll have some time for Q&A at the end of the presentations. So if you do have questions for any of our panelists, please do click the Q&A button that you should see on your screen and ask away. And so without further ado, I'm going to hand you over to Sinead Davies. So I'm going to ask, are you ready, Sinead?
I think so, yes. Can you see my screen?
Excellent. We can see and hear you well. Thank you. I'm going to hand you over now to Sinead, who's going to tell us about planning injunctions.
Thank you very much, Scott. So yes, I'm going to be talking about injunctions as a method of enforcement today. As I'm sure many of you are aware, a planning injunction is a remedy which is rarely sought by local authorities in the area of planning, and arguably without good reason. Obviously, classic enforcement mechanisms are sometimes more frequently used. Today, I'm going to cover 3 broad themes. Well, 4. Firstly, what is a planning injunction? Secondly, why we use them. Thirdly, I'll give some practical hints and tips. And finally, we'll cover some developments in the recent case law. Turning first then to what is a planning injunction. So the relevant provisions set out in the 1990 Act, and essentially it allows a local planning authority to apply for an injunction where it is necessary or expedient for an actual or intended breach of planning control, and where it's necessary for that breach to be restrained by an injunction. You might be thinking, why would I bother using an injunction? And the short answer is, it's a quick, effective method to seek compliance for a breach of planning control. There's a wide discretion given to the courts in granting such an injunction. They can injunct as appropriate for restraining the breach, and they can be relatively straightforward to obtain. So what do you need to provide in order to successfully apply for an injunction? Well, firstly, you need a witness statement that needs to detail any kind of breach, the nature of the breach, and any material harm which has been caused by the breach. It needs to be personally served on the defendant. An affidavit of service is the most helpful way of proving that service has been effective. And you need to allow sufficient time between the service and the hearing itself. This allows the defendant to seek legal advice and prepare a defence, and a general rule of thumb is that 14 days is normally appropriate. So if you're considering why we might even entertain the idea of an injunction, it's helpful to compare it with standard enforcement mechanisms. Take a normal planning breach, for example. There'll be a breach of planning control. The local authority would be satisfied that it's expedient to issue an enforcement notice. The recipient might appeal that notice. Both parties might file proofs of evidence. The appeal is heard at an inquiry or at a hearing. Sometime after the inquiry is closed, the decision is released. in which time the appeal is dismissed and the enforcement notice upheld. Then you have a period of compliance to afford the appellant time to remedy any breach of planning control. If they fail to do so, he's warned that he's committed a criminal offence and he's prosecuted for the same. The defendant may then enter a not guilty plea and end up in the Crown Court trial before a jury, and a number of months later is convicted and given a modest fine. And in the end, 2 years have passed, and the local authority may be more out of pocket to the tune of a few £1,000s, and the breach of planning control still remains unabated. That can be compared to an injunction, which, as I've already said, is a much swifter remedy and arguably more straightforward. And that really is the rationale underpinning why you might consider seriously injunctions for enforcement. So what do you need to satisfy the judge of? You need to satisfy the judge that they've obviously met the statutory test in the Act. They need to be satisfied that it's just and convenient, as well as a proportionate response, and that it adequately balances the interest, the public interest, that is, of upholding the integrity of the planning system and any material harm versus the private interest of the landowner to use their land. Consequences of winning. Obviously, you get an injunction, which hopefully abates the breach of planning control which you're alleging. Normally, you can recover your costs for investigating the breach and bringing the application in the first place. An injunction may also be accompanied by a penal notice that the defendant may be liable for a term of imprisonment if they fail to comply with the order, and that can mean that people take it far more seriously. Obviously, there are some pitfalls. A major one is that proceedings for breach of an order are brought in the way of contempt proceedings. You must therefore draft any order in very precise terms, because someone who has been charged with contempt need to know what exactly they're being charged with, and any ambiguity around an order is an opportunity for them to effectively wriggle out of any contempt proceedings. There's also a risk that you need multiple hearings, and the way to avoid that is to issue an application rather than a claim in the first place. That means that you can short circuit the need for first hearing and directions hearing, and hopefully the defendant is able to properly prepare their defence at court. So I've already covered this really. The advantages of an injunction versus conventional enforcement, for all the reasons that I've outlined earlier. It's quicker, it's a more effective and efficient mechanism, but also it can cover anticipated breaches. So to prevent further unauthorised development, you might consider applying for an injunction ahead of the actual breach. Okay, there have been two recent cases, but they've specifically related to the persons unknown jurisdiction. The first of those was the Bromley case, where London Borough of Bromley sought a final injunction to prevent persons unknown from making encampments in the borough for a period of some 5 years. This was over some 171 open spaces and car parks within the boundary, and the local authority argued that there had been a history of unauthorised encampments, and that there'd been a strong possibility that unless they were restrained by judgment, the respondent, persons unknown, would be in breach of the local authority's rights. The court in that case, the Court of Appeal in that case, gave some very wide guidance for local authorities who were seeking borough-wide injunctions against persons unknown. And while injunctions affecting wide areas may still be granted, it's now harder for local authorities to obtain them. And really, local authorities need to engage more fully with the gypsy and traveller community, who were the subject of the injunction in this case, in order to ensure that their interests are met. And the second of the two cases was the Barking and Dagenham case, which was quite widely discussed in the legal press. That too was a traveller injunction case, and that really did confirm that final injunctions, as in final injunctions over interim injunctions against persons unknown, were not really approved by the courts. The court set a number of safeguards to ensure that persons unknown injunctions were only granted in appropriate and very limited cases. That's it from me for now, and I believe we have a Q&A at the end, so happy to take any questions then.
Thanks, Jonid. Thank you very much. That was very helpful, very informative. I'm going to turn now, please, to Oliver. I'm going to ask Oliver Lawrence to join us. Oliver's going to tell us about the combined consequences of COMBU and CAMYAB.
Well, good morning, everyone. I just wanted to talk to you today about two cases in relation to POCA. And I've called my presentation Pitfalls in POCA. I was thinking of something a little bit snappier, like painfully obvious case law application. But of course, there's nothing painfully obvious about this at all. So I went with Pitfalls in POCA. But actually, what these two cases highlight is how these pitfalls are not really as dangerous or as large as they used to be, because we have two cases here where the courts have taken a slightly more realistic and lenient approach to the work that local authorities have to do in enforcing against breaches of planning control. So the first one that we're going to look at, COMDU, is in relation to, of course, a case which everyone knows now, called Wokingham and Scott, where the court essentially said that local authorities could not have regard to the potential benefits of POCA in deciding whether or not to enforce, and they declared that that was an abusive process. And so, as a result of that, local authorities' knowledge of potential sort of POCA benefits, POCA receipts, in their decision to prosecute, have been successfully used as a basis of attack of abusive process arguments in several recent cases. And despite the existence of the Home Office Asset Recovery Incentivization Scheme, or ARIS, and the encouragement that it gives local authorities to investigate and prosecute, frankly, since then it's seemed that any enforcement officer who so much as whispers the word POCA prior to the prosecution may well have doomed the case by doing so. As a result, we've seen large-scale phishing exercises where defendants seek disclosure, they trawl and scrutinize every email, memo, decision in relation to the council's prosecution policy, and these have become the norm. And so this recent case by the Court of Appeal, COMDU, seems to provide some form of safety net to local authorities and may indicate that the pendulum is swinging back towards a more balanced view of POCA confiscations in planning cases. So here we have the facts of the case. Here we go. Mr. COMDU was prosecuted for failing to comply with an enforcement notice, and this case was quite specific. He asked the Court of Appeal to allow a judicial review of the decision for the lower court not to allow him to vacate his guilty plea. Now, it's a bit legalistic, but what essentially happened was this. This man, Mr. COMDU, he converted his property into 8 self-contained units, and then he failed to comply with the enforcement notice, and he let those 8 units out for 4.5 years. And one of the things when he was prosecuted and ultimately convicted, one of the things that he then argued was that Enfield, the council, had been late in disclosing documents relating to his fishing exercise that he carried out, and that had he had those documents from the council before his hearing, he wouldn't have pleaded guilty. Why? Because he said those documents unequivocally showed that the council had a passion for POCA. They were motivated by the POCA receipts. And so obviously his barrister made many submissions about the propriety of the council's decision to prosecute, and that the financial investigator was very conflicted, and that if the officers had investigated the potential receipt prior to commencing the prosecution, their decision to prosecute must have been motivated by a potential receipt of around £300,000 entering the ARIS scheme. So these cases are delicate, because if abusive process is argued in this way, then what the courts essentially have to determine is the state of mind of the person involved, the person who took the relevant decision. And that can be difficult to do, and they often have to draw inferences from particular documents and particular communications. So what were those communications in this case? Right, so in this case, the planning enforcement officer sent an email to the investigator in which he said, they were discussing the case, this is what's going on, and he said, approximately £310,000 of benefit if you take into account all 8 units. So what do we think this means? I thought about running a poll, but I've decided against it in the interests of fluidity. So, as a standalone statement, do we think that this implies that the speaker is in any way incentivized by approximately £310,000 of benefit? Or is he just stating a matter of fact, reporting on the situation? It's not entirely clear. However, sadly for the council and well, fortunately for Mr. Comdu, it then gets a bit more clear cut because eventually what happens is that the officer emails the investigator again and asking him for an idea of the POCA income so that we may achieve for certain cases that we are prosecuting. And then he must receive the information, and then he eventually made a spreadsheet which included Mr. Comdu's property. And the relevant entry said this in the spreadsheet: benefit amount, £200,000, recoverable amount, £200,000. Incentivization, £75,000. A bit more clear cut there, certainly more clear cut than the previous example that some degree of incentivization was going on. The word is even on the spreadsheet. So we go back to the Wokingham case where courts, as we see here, they say where there's a financial interest in the outcome of the prosecutor must be scrupulous to avoid any perception of bias. The possibility of confiscation order being made, prosecutor's favour should play no part in the determination of the evidential and interest test. But what does that mean in practice? That's the difficulty. Our counsel is essentially required not to even mention the possibility of confiscation, which is obviously unrealistic. And so that's why this case is quite refreshing, really, because in this case, Comdu, the Court of Appeal took a more realistic approach. They said this. They said, it will often be necessary before a decision to prosecute is taken for someone within the council to consider the possibility that confiscation proceedings might be brought for various reasons. And then they say this here: there is a crucial distinction between investigators legitimately considering the possibility of confiscation proceedings and the decision maker being improperly motivated to decide in favour of prosecution by the prospect of financial gain to the authority. We are confident that the court in Wokingham had that distinction in mind when speaking, so we're not going to criticise that decision in any way. Well, everyone's grateful for that distinction. It's a very realistic one, but it's obviously incredibly difficult to know exactly what was going on in someone's mind all this time, and where does one draw the line between awareness and motivation? Because when considering, when considering the appearance of improper motivation of the decision to prosecute, the court had this to say. They said, it is important to remember that the yardstick is the view of an observer who is both fair-minded and informed. That means here that that observer knows all about ARIS and the incentivization scheme. They know about its consequences, and they know that the legal consequences may bring financial consequences for the offender and financial benefits to the prosecuting authority. So I think we're all grateful for this decision. It has often seemed that the courts have ignored that Parliament, in creating the scheme, the ARIS scheme, intended local authorities to be financially able to prosecute and confiscate, and indeed to be incentivized to do so. The word is on the tin. And this case makes clear that the existence of ARIS is not a bar to a successful prosecution. And the fact that it might result in POCA receipts for the local authority doesn't make the prosecution an abuse, and this is helpful because it means it'll probably cut down on the scope for fishing exercises, which might lead to sort of easier, smoother litigation going forward. But the decision is obviously not a get out of jail free card. The Wokingham trap is still there for local authorities to fall into, and any communication that clearly implies that that the relevant decision maker is motivated by the prospect of receipts, that will still present real problems for enforcing. The abusive process of the court is essentially a high bar. And that's what Wokingham achieved, but that's not what Mr. Comdo achieved in this case. So clear going forward, local authorities still have to put a lot of effort into making sure that they take their prosecution decisions conscientiously, not for the purpose of receipts. But it's a difficult line. I mean, the fact that local authorities obviously they only have so many resources, and they have to pick their battles. That was submitted to the court in this case, but the court offered no further guidance as to what it had to say in general terms. However, there's no doubt about it. Here we see this image because, in my view, it's an indication that the pendulum is swinging back at last towards a slightly more lenient approach towards local authorities and whether or not they have been motivated by the prospect of POCA. Another case now, moving on to a completely different kind of pitfall, and it's a brief point, but also sort of provides some respite. So here you have a case of Kamyab, and in order to understand this case, you have to sort of look at a previous case where the Court of Appeal ruled in the case of Panayi. And this rather unhelpful case concerned essentially a drafting error. Here, the council had drafted its summons to refer to non-compliance on the single day on which the site visit was undertaken, because that was the day that they received first evidence of the offence. Essentially, the officer went to inspect the site on a particular day, saw that there was non-compliance on that particular day, and therefore that went into the summons. And as a result of that, yes, so this is how the summons was drafted. Failure to comply on or about, I've put in the 4th of February 2014. That word on really presented difficulties for the local authority in this case. And the court in Panayi, they took a look at the wording of that summons, and they said, well, it's clear that the alleged the offence specified, the alleged failure to comply, is compartmentalized and is only referred to as taking place on a specific day. And as a result of that, the benefit confiscated could only be the rental income in this case for that specific day. And so since then, the case essentially created a trap for local authorities to fall into. But a relatively easy mistake to make. It doesn't require Homer Simpson. How to draft the summons accurately so that the whole benefit confiscated is one which reflects an offence which, of course, is committed over a period of time, over a long period of time, to make sure that what's confiscated is the proper amount. So since then, a number of cases have sort of slightly eroded what the court had to say in Panayi, this rather strict application of summons interpretation. And now finally, we have this case of Kamyab, where the summons was drafted very differently. So here the facts in Kamyab, were these. Here we had Mr. Kamyab converted a 5-bedroom house to 9 flats, enforcement notice issued, upheld, compliance visit takes place, 4th of February 2014. Mr. Kamyab duly prosecuted, convicted in 2015. And his appeal was dismissed, and so the case went to the Crown Court for confiscation. So here the summons alleged failure to comply on or before 4th of February 2014. So again, slightly different. But again, the question is, has this summons fallen into the same Panay trap? Are they referring to an offence committed on a particular day? So Mr. Kamiab relied on Panay, and he offered the generous amount of £58 in confiscation as the income that he received on the 4th of February. And so the matter was referred to the Court of Appeal. So the Court of Appeal took a look at how the summons was worded. What was the exact offence specified? And they found that, as worded, the summons in Kamiab was not a single day offence. It decided, they understood that the very nature of these offences, section 179, that these are single offences which are always committed over a period of time, usually. It would therefore take a lot to conclude, they said, that it was a single day offence, almost no matter how it was worded. So they're being sort of very kind of lenient there in saying that, well, you have to interpret these summons against the backdrop of the nature of these offences. And so on or before 4th of February, we're going to take a broad brush approach to interpretation there. That's an offence going back some period of time. And so on the interpretation of that summons, the offence is specified to not take place on a single day. And here we have what they had to say about the case of Panay. They were asked to say it was bad law, but as can be the case, they found a way to stop short of doing so, saying here we certainly agree that where Panay can be distinguished, it should not be applied. So, stopping short of going so far as to say that decision was completely wrong, and just simply saying that it should be distinguished in the future. And they note within the judgment, they of course noted that best practice is for planning enforcement offences to be drafted as a failure to comply between two specified dates. So from this date to this date, this is when the offence took place. From the date that compliance was due to the date of the summons, and this would avoid any issues. But that's what best practice, of course, is. That's what should still happen, but there's no doubt this case has created a safety net. So good news for local authorities across the board. Thanks very much. Back to you, Scott.
Thanks, Oliver. I think it sounds like the overriding message is local authorities still need to be a bit careful when they're thinking about what it is they want to achieve out of prosecutions and how it is they want to draft their summonses and charges.
Absolutely. I mean, I say a safety net has been created, but we can see the legal consequences, protracted litigation of how it can go wrong, and the arguments that defendants have essentially if the summons is ambiguously worded. Yes.
Thanks, Oliver. Now we're going to turn to Howard Leithhead, who, from the looks of his slides, he's had some shopping delivered. Howard.
Good morning, everyone. It's been a busy summer for enforcement cases. I'm going to talk to you about 4 cases which are relevant this morning. All have taken place since June. The cases are on Ocado Retail Limited and Islington London Borough Council, Bansal and the Secretary of State, McGaw and the Welsh Ministers, and CPRE Kent and the Secretary of State. Ocado or Ocado, first up. In this case, a successful application was made for a certificate of lawfulness of existing use or development, commonly known as a CLUID, under section 191 of the Town and Country Planning Act, which established the lawful B8 use of 4 units on an industrial estate. The applicant had relied on the 10-year rule under section 171B3 following a breach of condition. Ocado then entered into a lease for the units and submitted a planning application. Opponents of the planning application submitted documents relating to the planning history of the site and asked the council to exercise its powers under section 1937 to revoke the CLUID. The council investigated and revoked the CLUID on the basis that there had been material false statements and withholding of material information in the CLUID application. The decision was accompanied by a delegated report, and this stated, among other things, that the CLUID application and decision had proceeded on the incorrect legal basis that the issue was whether there had been a 10-year continuous breach of condition at any time in the past, without that lawful use being subsequently abandoned or suspended. Ocado then challenged the decision in the High Court by means of judicial review, and Mr. Justice Holgate dismissed the claim. There are 3 points from the judgment. It's a very long judgment, but I want to focus just on 3 points for you this morning that I think are of particular interest. The first is about the meaning of material information withheld in section 1937B. The second point is about the time when a lawful planning right accrues, and when the time limits under section 171B apply. And the third point is about the council's reasoning in relation to its consideration of the relevant planning unit and the issue of abandonment. So, to the meaning of material turning first to the meaning of material information and withheld in section 1937B, and the sections there on your screen. Subsection 7 says a local planning authority may revoke a certificate under either of those sections if, that's sections 191 and 192, on the application for the certificate, A, a statement was made or document used which was false in a material particular, or B, and this is the relevant part, any material information was withheld. The judge rejected Ocado's argument that information must be deliberately withheld for a fluid to be revoked under section 1937B. Mr. Justice Holgate further said that to be material, information had to be relevant, but also significant. And he said that the test was satisfied if information could have resulted in the council making a different factual finding or drawing a different inference to one made previously, or a line of inquiry leading to that outcome, and that could have resulted in the application for the certificate being determined differently. The judge also said that the council was entitled to consider the materiality of matters cumulatively as well as individually. The second point is that the judge rejected the council's argument that the law required a breach of condition to have continued for at least 10 years, up to and including the date of the application for the fluid. The judge said that a lawful planning right accrued upon the expiry of a time limit under section 171B is not lost simply because it is not exercised for a period of time. For the right to be lost, there must be some kind of supervening event, such as abandonment. In the case of a fluid application, the judge said that it is relevant whether that right is still being exercised on the date of the application. And the third area is the council's reasoning in relation to its consideration of planning of the relevant planning unit and abandonment. In respect to this, the judge noted that it was agreed that the identification of a planning unit was a key factor in determining the existence of a lawful use right and the area to which it applied, and that any B8 use right which had accrued could be lost by the formation of a new planning unit. The judge said that it was not irrational for the council to revoke the fluid on the basis that further inquiries needed to be made as to whether the planning unit had changed. And similarly, the judge said that there was nothing irrational in the council's identification of false statements or information withheld as being material to the issue of whether the B8 use had been abandoned. So just summing those points up to provide some practical takeaway points. When considering revoking a lawful development certificate on the basis that material information was withheld, first, the information does not have to have been deliberately withheld, but the information does have to be relevant and significant in the sense that the information could result in the LPA making a different factual finding, drawing a different inference, or pursuing a different line of inquiry, and that this could have resulted in the application being determined differently. The second point is goes beyond LDCs, obviously, and this is that when considering the expiry of a time limit under section 171B, the right isn't lost simply because it hasn't been used. There must be some kind of supervening event, such as abandonment. And the third practical point I suggest taking away is that in considering enforcement action where reliance is placed on a time limit under section 171B, consider whether the planning unit has changed. An example of a circumstance where this might be the case is where there are a number of buildings within the original unit which might have been occupied differently over time. Bansal, the second case, also involved interpreting the time limits under section 171B. In this case, the High Court considered how the 4-year rule under section 171B2 operated, where a dwelling house was converted into 2 self-contained flats. In this case, the appellant converted a dwelling house into 2 self-contained flats in breach of planning control. One of the flats was on the ground floor and the other was immediately above it. I'll call them the ground floor and the upstairs flat. The council issued an enforcement notice requiring the cessation of the use of the property as 2 self-contained flats and to carry out various other related works. The appellant appealed to the Secretary of State relying on ground D and argued that enforcement action could not be taken as more than 4 years had elapsed. The inspector found that there was sufficient evidence that the upstairs flat had been occupied continuously for more than 4 years, but that there wasn't sufficient evidence that the ground floor flat had been. Consequently, the inspector decided that there was insufficient evidence before them that the property as a whole was in use as 2 self-contained flats for the relevant period, and they dismissed the appeal. The appellant then appealed to the High Court under section 289. He argued that the inspector's conclusion was irrational and that the inspector had failed to have regard to a relevant consideration, which was whether the physical works were indicative of a change of use. In the High Court, Mrs. Justice Lang dismissed the appeal. She said that it was rational for the inspector to require the appellant to establish that both flats had been occupied as separate dwelling houses for more than 4 years before the enforcement notice was issued. She also said that it was not enough for the appellant to demonstrate that the conversion works had been carried out before the 4-year period, or that the first floor flat had been occupied throughout this time. So, practical takeaway points. First, if considering taking enforcement action against the material change of use of a dwelling house into separate flats, and whether the 4-year rule under section 171B applies, then ask for evidence that each individual flat has been occupied for the relevant 4-year period. And as a further note, this wasn't an issue in this case, but it seems to me that it's worth remembering that the time periods under section 171B can be disapplied in certain circumstances. One example is if there has been deliberate concealment, the council is able to obtain a planning enforcement order. This is less complicated than some people think. In my experience, local authorities aren't making use of it in circumstances where they could, and the threshold for deliberate concealment is low. The third case is Magor and Welsh ministers. In this case, the Court of Appeal considered how to measure the height of a proposed building from the surface of the ground immediately adjacent to it, as required by Article 1.3 of the 1995 GPDO. Now, it's important to bear in mind from the outset that the 1995 version of the GPDO is the version that applies in Wales. In his judgment, with which the rest of the court agreed, Timothy Lloyd said that the 1995 GPDO should be interpreted in the light of its statutory purpose. This was, he said, relieving developers and planning authorities of an unnecessary regulatory burden in cases of a kind where planning permission ought to be granted, and reading both the words which set out what is permitted and those that limit the scope of the permission in a broad and common sense way, according to the ordinary meaning of the language used. The court held that height measurements did not necessarily need to be taken on land within the curtilage of an applicant's land. In circumstances where the proposed building would be flush against a brick wall, it'd be appropriate to measure from the neighbour's land on the other side of the wall. Lord Justice Lewison, in his judgment, noted the conundrum posed by the requirement to measure the surface of the ground immediately adjacent. On the one hand, he said the surface of the neighbour's land was not immediately adjacent to the proposed building, but on the other, what was immediately adjacent was not the surface of the ground. He said he didn't think it was possible to resolve the tension between the two by purely linguistic means, and that a pragmatic choice had to be made. He also said that he thought it might be possible for those responsible for drafting the GPDO to make it a bit clearer. Now, in terms of practical points, the first point is to state a note of caution. And I suggest caution for two reasons. The first is that the factual circumstances of each application need to be considered. And the second point is that Article 1.3 is worded differently in the 2015 GPDO, which applies in England. However, more generally, this case is a useful reminder that the GPDO should be read in, quote, a broad and common sense way according to the ordinary meaning of the language used. And the final case I want to talk about this morning is CPRE Kent. This is a Supreme Court case. This concerns planning statutory reviews and judicial reviews. In this case, the Supreme Court held that defendants and interested parties have a prima facie entitlement to receive their costs if they file an acknowledgement of service and are successful at the permission stage. However, costs must be reasonable and proportionate to be recoverable. The court quoted an example of a situation where costs might not be recoverable, and this was an example given by Lord Justice Coulson in the Court of Appeal below. And Lord Justice Coulson said, if there is an obvious lead defendant and the court was not assisted by the acknowledgement of service or summary grounds of an additional defendant and or interested party, then the costs of that additional defendant and or interested party may not be proportionate and so will not be recoverable. In terms of practical points, I'd suggest there are three. The first is that it's important to note that this prima facie entitlement to cost doesn't apply to appeals under section 289, where there is no requirement to file an acknowledgement of service. And I've had questions specifically on this point from solicitors. In these appeals, generally only one set of costs is allowed, but the court will consider such matters as whether a party has a separate interest, the extent to which different arguments were advanced, and how far that second party assisted the court. If counsels are unlikely to get their costs as a second defendant, why should they then get involved? And my advice is that the main reason for doing so is that it makes sense for the counsel to preserve its position in case the lead defendant decides not to defend the decision. The second or third party, depending on how you look at it, may also be of some assistance in successfully defending the appeal.
Thanks, Howard, and thank you all very much for your presentations. They were very, very thorough and helpful and informative. Well, thank you all very much for joining us here today on our seminar for what has been a very wide-ranging and informative talk through injunctions, through POCA, recent case law on certificates, costs, and others. I want to say thank you on behalf of all of the attendees to our panelists for their presentations. And just to remind you all that if you want a copy of the slides for today's presentations, please email marketing@number5.com. And secondly, that a feedback form is going to be emailed out to you in a few days. Please keep an eye out for it in your inboxes. If you could complete that, please, and send it back. It is very helpful to us so that we hear and know about what topics you want to hear from our speakers on in future presentations. So thank you very much all for joining us today. That's been our talk on Planning Enforcement Revisited. I hope you've enjoyed it as much as I have, and we'll see you again soon in another presentation. Thank you.